Good morning and welcome to our final webinar of Leasehold Knowledge Week. This morning's session is presented by Dani Green, Senior Associate, and Verity McMahon, Associate at Brethertons. This is a second chance for anyone that missed their live workshop at the conference earlier this week to hear about the popular topic of lease extensions and hear their step-by-step guide. If you have any questions throughout the webinar, please post them in the Q&A box at the bottom of your screen. And we will try to get through as many as possible at the end. The session is also being recorded and will be available to watch back via the News on the Block YouTube channel later today. I will now hand you over to Verity and Dani so they can begin.
Come off mute. Thanks, Vicky. So thanks for the introduction. That saves us a job. As Vicky mentioned, we're here to talk to you about lease extensions, give you a step-by-step guide. Just so you know, as you can see there, it's mainly the statutory lease extensions we're going to be talking through today. We do touch on a bit of the voluntary lease extensions, but you will shortly see what we're going to talk about. This is Verity and I. These are our contact details, so if you do have any questions that you think of and you haven't shared them at the end, or you want to get in touch with us afterwards, then please feel free to either drop us an email or give us a call. And being lawyers, here is our typical disclaimer, just to let you know that obviously everything that we are saying is accurate, but obviously on a case-by-case basis, things do change, things don't always go to plan. So if there is a very specific matter that you are dealing with or you want to know about or have a question about, it might not sit exactly in this step-by-step guide that we're talking about, so please do get in touch so that we can consider that exactly on the facts.
Okay, so what will we cover today? The idea is not to give you a in-depth law lecture about statutory lease extensions. It's to give you a step-by-step guide as to the elements involved and some key elements to be aware of when you're advising a client that comes to you that needs a statutory lease extension. We have based it on a straightforward statutory lease extension, so just bear that in mind. A lot of things can go wrong, which we'll touch base on throughout. And obviously, it is a lease extension under the Leasehold Reform, Housing and Urban Development Act 1993, which throughout we will call the Act or the 1993 Act, so we don't have to get tongue-tied.
So who are we looking at when we're talking about a lease extension? There can be many different parties involved. The more straightforward, simple matters, you would say, would probably just have a landlord and a tenant. In practice, that doesn't happen too often. There are a few times it does, but sometimes you can also have a management company involved if there's a third party to the lease. Sometimes you can have two management companies or third parties involved. You might have a competent landlord, so for example a freeholder. You might have an immediate landlord, somebody who is your immediate landlord but can't grant the lease extension because their lease isn't long enough. You might have a few immediate landlords as well, or intermediate landlords, so there can be quite a few parties involved during a transaction. Something to be aware of is obviously if it's a statutory lease extension, then you can be open to a conflict of interest by acting for more than one party. That's quite different to a voluntary lease extension where if all of the terms are agreed and the parties don't have any issue with it, then they can instruct the same solicitor to deal with the lease extension. We've pointed it out as well because it's something to bear in mind at the very outset, especially if you are acting for a tenant. That tenant will be responsible under Section 60 of the 93 Act for the reasonable costs incurred by not only the landlord, but also any relevant persons. And Section 66 does state that a relevant person is obviously the landlord, but any third parties to a lease as well. So if you have got management companies, then they can obviously be looking to recover their reasonable costs for being involved, being advised on the lease that's obviously drafted and agreed, and then arranging signatures of that lease as well. So just be mindful of that at the outset. And where you have intermediate landlords as well, they might be serving notices of separate representation. So if they do that, they will probably have solicitors involved, and their reasonable legal costs could be sought from the tenant as well. So it's just worth bearing in mind, it's not always two parties, a landlord and a tenant. You can have these other parties involved too.
Okay, so a statutory lease extension, you have to qualify to exercise the right. The 1993 Act sets out that all residential flat owners are entitled to a 90-year lease extension. So that's in addition to the unexpired term left on their lease at a peppercorn, which is 0 ground rent. They're entitled provided the property is a flat, and that's under section 101 of the Act. It's normally pretty self-evident if a property is a flat, as we all know. It forms part of a building that's constructed or adapted for the purposes of that. And either the whole or a material part which lies above or below the other part of the building, but do beware of abnormal situations. You could come across situations where it would normally be considered a flat, but it's actually defined as a house under the purposes of the lease. So your first point of call is to always check your lease for the definition of the demise. Always look to the use of the flat as well. For example, if it's a bed and breakfast or a service department, it might not be considered a flat for the purposes of the Act, but there's still a lot of debate surrounding this. It has to be a long lease, so the original term has to be over 21 years, and this has to be owned, the leaseholder has to own the property for a continuous period of 2 years prior to the relevant date, and that's under section 39(2). Do beware of certain situations to this. So this is the period that starts from the date that the tenant was registered at the Land Registry, not from the date that it was transferred to them, which is an area that a lot of solicitors can slip upon. If the lease has already been extended, this goes from the date that the later lease was registered at the Land Registry, not the original lease, so be aware of that. Beware of if you're dealing with probate. The right can be registered by the deceased proprietor's personal representatives, and they have 2 years from the date of the grant of probates or letters of administration to exercise that right. You want to avoid situations where the property gets transferred to the beneficiary before that right is exercised, because then the beneficiary won't fall into the 2 years qualification, only the executor of the deceased tenant will. So just be aware of that. I've had a few situations where that's happened. And again, be careful if you're dealing with a bankruptcy. So neither the trustee in bankruptcy of a tenant nor the receiver of a bankrupt tenant's mortgagee can rely on the bankruptcy period of occupation. So the 2 year rule always vests in the bankrupt tenant, not the receiver. All of this is in return for a payment to the freeholder. So provided you qualify, you have to pay the freeholder what we call a premium, which will need to be assessed by a specialist valuer. You will never qualify for a statutory lease extension if the landlord is a charitable housing trust and the flat is part of the charity's work. So you will never qualify in that situation. Or of course, if it's a business or commercial lease, this is an exclusive right to residential flat owners only.
So another thing to kind of consider at the beginning is whether or not you have all the right information and you know where you're going to be serving your notices at. The best thing to do is to ask for the latest ground rent demand from the tenant. That ground rent demand should, or be well, have notices for, an address for notices to be served at for the landlord. And that's the most up-to-date information that you will probably have received from the landlord with their address. That said, if you have any concerns or any queries as to who the landlord is. For instance, if you've got an immediate landlord, but there are freeholders, there could be more intermediate landlords in between, you're not sure. You can serve a request for information on your immediate landlord, asking them if they know of any other landlords, and if so, what are their names and addresses, and then they will have 28 days in order to give that information. So it's worth bearing it in mind if you have got some question marks over who the right landlord might be for the notice to be served on.
Okay, so once we're satisfied, we know who we're serving our notice on and we qualify. The first step would be to assess how much the lease extension is going to cost for the client. We do this by appointing a specialist valuer. It's always recommended to appoint a specialist valuer, but oddly, it's not a requirement. If you don't appoint a specialist valuer, or your client's insistent that they don't want to, just beware of invalid offers. You cannot put an unreasonable offer in a Section 42 notice. So you couldn't offer £1 for a lease extension. It needs to be valued in accordance with the statutory formula that's in Section 13, Part 2 of the Act, which is why us as solicitors get valuers involved, as it would be negligent for us to advise on this. Once your valuers assess this, they will produce a valuation report which will contain a best and worst case scenario for the client, with an advised opening offer, which tends to be just below the best offer. If there are multiple landlords, so you have a head lessor involved, the report will also outline how this premium is split, which must be shown within the body of your Section 42 notice, which Dani will go on to talk about in a minute. The most important thing about the valuation exercise is to identify, as a solicitor, before we even get going, whether marriage value will be applicable. For instance, if you get a client approaching you and their lease is approaching 80 years, there's obviously some urgency with this, and you need to action and get that Section 42 notice served before it drops below the 80-year mark. Otherwise, you can go from quite a modest premium. This can sometimes triple overnight. So it's always good that they get this valuation advice quick and before it drops below the 80 years. The solicitor works obviously quite closely with the valuer, so it's always best to ensure open communication. We'll go on to talk about key dates shortly, but we need to make sure that we are aware as solicitors when the premium gets agreed, and the valuer needs to be aware when the terms of the lease get agreed as well, because together they can create a key date in the process. An interesting point on valuation: the tribunal will never be able to determine a premium higher than the landlord's counteroffer or lower than the opening offer proposed by the leaseholder in the Section 42 notice. So this is why it's vital to get advice and make sure that we are giving reasonable and fair offers from the outset.
Okay, so we've got our valuation, and the next step then is to prepare our Section 42 notice of claim. There isn't a prescribed form, but it must be in writing. Section 42(3) sets out what needs to be included in the notice, and not including something can invalidate that notice. So it's very, very important to make sure that all that information is in there. That information includes stating the full tenant's name and the address of the flat. It needs to contain particulars so that you can identify the flat. So again, the property address, perhaps what floor it's on, if there's a title number of it at the Land Registry, edging red on a plan and showing where it is. And you also need to give particulars of the lease. Notably, you need to state the date of the lease, the term of the lease, and the commencement date of that term as well. The best thing to do is to put all the information in for that lease, so naming the original parties to it as well can always help, just so that you haven't got any arguments coming your way. You also need to, as Verity mentioned, you will need to specify the premium. So not just the premium to the competent landlord, but also if there are any other landlords, any sums that might be paid to them under Schedule 13. So you'll have to list those as well. If you haven't, it's good practice to put nil, so that to acknowledge that you have seen that there are none and you're not expected to pay anything under Schedule 13 to any other landlords. You need to also specify the terms that you want in the new lease. So if there are any amendments, if you are looking to modernise the lease, if you are looking to rectify any defects in the lease, delete any clauses, amend anything, then obviously include that in your notice. You need to state what it is that you're looking for that new lease to do. You also need to state the name of the person who's been appointed to accept service of any counter notice. So if the tenant has a solicitor, you'll be putting your details down there and obviously the address for serving that counter notice. And importantly, you need to put the counter notice deadline date in. So under section 42.5, you need to put a date that's not less than 2 months from service of the section 42 notice. That means if I were to serve the notice today, being the 25th of March, if I put exactly 2 months down, being the 25th of May, if I'm serving this notice today by post, it hasn't been served today. So putting a date of the 25th of May will invalidate my notice because I haven't given 2 full months or more. In practice, what we do is we give some time for service. So we will usually put a counter notice deadline date of, say, 2 months plus a week, maybe plus 2 weeks, especially over Christmas where there are bank holidays. If you're serving a notice on Christmas Eve, you've got to think of the bank holidays that are there as well. So make sure you give enough time for your section 42 notice to have been served so that the landlord has 2 full months in order to serve their counter notice. The next thing to consider is who are we serving the section 42 notice on? Of course, we're going to serve it on our landlord. If we have immediate landlords as well, we also need to serve it on them, and any third parties to the lease. That tends to catch out a lot of solicitors. They don't realise that they do need to serve it on the third parties to the lease. And when the landlord's solicitor comes to ask for evidence of that, they can become a bit stuck. So not serving it on the third parties will invalidate the notice. So just make sure that it is also served on them. And where do you serve it? I mentioned earlier that you might have a ground rent demand, which will give you your landlord's address for notices to be served at. You might have done a request for information, so you might have addresses of any other landlords as well. You can also look at the freehold title or the head lease title at the Land Registry and see what the address is on there. If it's a company, you can be checking at Company's House as well to see what their registered office address is. And of course, you can always revert back to the original lease if they were a party to the original lease and see what address for service they had put in there. If you get stuck, if you're not sure which one to send it to, the best thing is to serve it at all of those addresses, unless you know for sure that those addresses are not used anymore. The best thing to do is to serve at every address that you've got to make sure that it has been served at the right one. Before serving the notice, you might want to be asking the tenant for the deposit on account ready. Verity will discuss that in more detail shortly, but it's best to ask for it up front because you only have a limited time to arrange the payment. And if you have signed the notice on behalf of the tenant, so if they aren't signing the notice themselves, you should be asking them for authority to do so, ideally in writing, because the landlord might be asking you for evidence that you had authority to sign the notice on their behalf. So do just make sure you have that on file ready for if the landlord requests it. In terms of serving the notice itself, it must be in writing, as we've said, and so it may be sent by the post. We've obviously, throughout the pandemic, we've understood that that's not always the best method of service. It's not always the easiest if people can't get into the office. And so there have been times where parties have agreed between themselves that they will accept service by email. I think the important thing to note is that that is not a general rule. A party doesn't have to accept service of a Section 42 notice by email. So don't simply just rely on sending it by email, that's fine. If you are looking at serving it by email, then make sure that you have asked the landlord, the management company, whoever that might be that's receiving it, that they will accept service by email before you rely on that. You should also be serving original Section 42 notices and not copies, so wetting signatures. The best thing to do is make sure you print out enough notices, sign all of them, and then every party has an original as well. Dani and Smith that's a bit of case law that says even though it related to a counter notice, we can still look to rely on it for a Section 42 notice. So the burden lies with the sender to prove that a notice was properly posted. The best way to do that is to send it by recorded or special delivery, keep the receipts to show that it has been sent, and worst case scenario, personal service, get a courier, that kind of thing. When we've served our Section 42 notice, we can apply to the Land Registry with a UN1, so a unilateral notice. That will put a notice onto our landlord's title that will say we have applied for a lease extension, and that then makes it known for any potential buyers who might be looking at buying that freehold or head leasehold title, that even if they do so, they will still have to go through and grant this lease extension. And finally, just to mention assignments. We do touch on that at the end, so I won't go into too much detail on that yet. And Verity's also mentioned, or she hasn't yet, she will, personal representatives. So if you have got, if it's a bit outside of the norm, if your tenant is looking at selling, or if you have somebody who's looking at buying, you might need to consider assignments. If you've got, if you're acting for personal representatives of an estate, it's important to make sure they haven't changed the title from the original owner into their names, otherwise they lose their 2-year ownership and can't apply. So they keep it in the original owner's names, but if they are getting grant of probate or letters of administration, they only have 2 years for getting those in order to make their Section 42 notice.
Okay, so once we've served our Section 42 notice, between the period of time of service of the Section 42 notice and the landlord's counter notice, so that 2-month, 2-week given for service period, they can make a few requests about your client's claim. The 2 most usual requests are on your screen at the minute. So a request of payment of deposit. It's in the 1993 regulations, Schedule 2, paragraph 2.1, and this is to be paid within 14 days. So as Dani mentioned, it's always wise to get this payment on account before you even serve the Section 42 notice. What you don't want to be happening is you're offering hundreds of thousands of pounds for a lease extension, meaning the deposit of 10% is quite substantial, and you haven't warned your client that this is payable before completion, nor have this on account, causing a bit of a panic to get this all sorted out within 14 days, as they might need some time to organise this, and it's always good to give your clients the heads up that this may be coming. The leaseholders will have to pay the greater of £250, so £250 is the minimum deposit that they will have to pay to the freeholder, or it will be 10% of the premium proposed if it's higher than £2,500 that you've offered. The point of this is to ensure that the landlord has a retention for their fees should your claim be withdrawn. So if for whatever reason the claim is withdrawn and your client no longer proceeds with the lease extension, the deposit will be returned, but less the landlord's reasonable costs for dealing with the claim so far. If it all goes smoothly and you head towards completion, the deposit will be used against the overall premium payable for the lease extension, so it will be deducted at the end. The second usual request is to deduce title, which is a fancy way of saying prove that your client qualifies. This is where the landlord will check the name of the tenant, the details of the lease and the period of the ownership, especially the period of the ownership, to ensure that your client qualifies for a statutory lease extension, which is what I touched on briefly earlier. This needs to be provided within 21 days, so different from the 14 days, but we usually find that both of the requests come through at the same time. If the claim has been assigned, which Dani will talk about later on, so if it is that you've assigned the claim to an incoming buyer, that needs to be deduced too, so you will need to deduce the deed of assignment that goes with that. And what we usually do is ensure that we have a leasehold office copy entry on the day that we serve the section 42 notice, so it cannot be disputed at all that our client owned that property on the day the notice was served. Okay. The third likely request that you'll get is a request for inspection. This is obviously so the freeholder's valuer can go and inspect the property for the purposes of their valuation, so they can establish what they'll put forward in their counter notice. Under section 44 of the Act, they only have to give 3 days notice and can visit multiple times if necessary. Should you have multiple landlords that you're serving this notice on, they can be exercised by all of the landlord's valuers to assess the premium offered and apportioned. So it might be the case that your client has multiple inspections by different people. So again, something to warn your client about. It can be some clients find it quite invasive. So, you know, you reassure them that it is a normal request and the reasons for doing so. Proof of authority for signing section 42 notice from the tenant. So if you are a firm of solicitors that signs your notices on behalf of the tenant, which a lot of solicitors firms do, please make sure you have written authority from all, not one, all of the tenants registered. This is important because, as Dani mentioned, this can be requested by the freeholder solicitor as evidence. If you haven't got it, your claim can be invalid and you have to start all over again and have repercussions for costs. So that is very important. Evidence of service on any third parties. Again, this is where solicitors can come unstuck. Do not forget that management company. Do not rely on the Land Registry. They can sometimes miss the third party of the lease out when they list the details of the lease. Make sure you are looking at the original lease for the management company and make sure you have track service and you can prove that to the freeholder should they require it. Should you not comply with any of the above, especially the deducing title and the deposit, there are no sanctions for non-compliance, but the landlord can serve a default notice under section 92 and ultimately apply to the county court to enforce that. That would probably be more applicable should a big deposit be involved, and we're talking about big premiums. So just be aware of that should you not comply within the time period specified.
So our 2 months and 1 week, 2 weeks, however long it is, deadline is approaching. The landlord will be serving their section 45 counter notice. They can serve it sooner. It's quite rare, to be honest. They will usually wait until the last moment, maybe a week before, maybe a couple of days before. But as long as they serve it by your deadline, then that's fine. Now, their section 45 counter notice needs to either admit or reject the claim. If it doesn't do either of that, it needs to explain that it's planning to redevelop and make an application in that regard. So the usual counter notices will either admit or reject the claim. If they are rejecting the claim, it's on the basis of the tenant not qualifying. So it's not because they've simply missed something in their notice and made their notice invalid. you will usually be notified that a notice is invalid quite early on, so that it can you can serve another one without prejudice to the validity of the first. But usually, most of the time, if you've got your Section 42 notice correct, you've served that and the tenant does qualify, then the landlord has no alternative but to admit the claim and admit that the tenant does qualify and has a right to the lease extension. Within their counter notice, again, similarly to the Section 42 notice, the Section 45 counter notice has some very specific things it needs to include. So it needs to state for each proposal made by the tenant, which of those is accepted and which of them are rejected. So, for example, they might reject the premium that's been proposed, but they might accept some of the terms that have been offered, such as modernising, maybe deleting specific things or adding specific things into the lease. For anything that the landlord rejects, they need to make a counter proposal for. So they can't simply just reject it, I don't agree with your premium, and not make any counter offer. Otherwise, it looks as though they have accepted it. So for a rejection of the premium, they need to make a counter offer. Now, the landlord doesn't have to make a reasonable counter offer for a premium, whereas the tenant has to make an opening shot of negotiations and not simply just offer a pound. The landlord doesn't have any similar rules for them. Their counter offer can be anything. They can literally go as high as they want. There is nothing outrageous in terms of their counter offer. Most of the time, though, landlords do put something in that you would expect, obviously a little bit higher because the parties are going to negotiate. Once the counter notice offer is served, this will start a new clock, which will mean that you have a key date of 6 months from the counter notice being served. In either, you will need to agree the terms of acquisition, which are twofold, which I'll come on to in a moment, or if those terms have not been agreed, then you will need to have made a first-tier tribunal application. If either of those things haven't happened and the 6 month deadline comes through, then the claim is deemed withdrawn. Deemed withdrawn, that will mean that the claim is no more. The tenant will be responsible for the landlord's reasonable costs incurred under Section 60 to date, and then the tenant can't actually make another claim for a lease extension for 12 months. So it's quite important to make sure that you are aware of that 6 month key date. It is diarised everywhere. Don't just put it in one place. Put it in the your Outlook diary. If you've got a paper diary, put it in that. If you've got a case management system, put it in there. Put reminders in beforehand as well, a month before, 2 months before. Make sure you keep on top of that date. If that date is approaching and you haven't agreed the terms of acquisition yet, then you need to be making sure you're ready to make your tribunal application. A tribunal application can be made after 2 months of the counter notice being served. That might be beneficial where you know you've got a landlord that perhaps never agrees a premium, never agrees the lease. You know this is probably going to go to the tribunal, so what's the point in having 6 months of negotiations? Get that application in sooner so that the parties can just resolve matters, get things determined, and move towards completion sooner. The other thing that will or could happen after a Section 45 counter notice is served, if you have any immediate intermediate landlords, that will then be the time that they will serve any notices of separate representation. So if they want their own separate representation, they've got their own valuer, they want to make sure that they are receiving the right premium for themselves, then they might serve their notice at this point. That means that they have probably got a valuer, they have probably got a solicitor representing them as well. So though they will need to be involved throughout the process. I mentioned terms of acquisition. It is twofold. So it means that the premium has been agreed and it also means that the lease terms have been agreed. The two are quite separate. So a valuer will usually deal with any premium negotiations. As solicitors, we don't get involved in the premium negotiations, as we don't get involved with the valuation itself. We'd be negligent to do so. We're not valuers, it's not our expertise. So the valuer will negotiate the premium, the tenant's valuer and the landlord's valuer, and then the solicitors are there to negotiate the terms of the lease. It's important to point out that the terms of the lease do not mean agreeing the draft form of lease itself. So it doesn't mean asking for a copy of the draft lease and then once you say, yes, this is approved, that is all agreed. It can be possible for a Section 42 notice to state that the lease terms the tenant is looking for are to be modernised. The landlord in their counter notice could accept that, not reject anything in terms of the lease terms, not have made any counter proposals, and that in itself means that the lease terms would have been agreed. So without having seen any draft form of lease itself and actually go through it, you can have the lease terms agreed. This is why, as Verity mentioned, it's so important to have a solicitor and a valuer who work well together. They are communicating. If those lease terms have been agreed throughout the Section 42 and the counter notice, as soon as the valuer then agrees the premium, the terms of acquisition have been agreed. So it's very important for the valuer to keep the solicitor up to date in terms of those premium negotiations and vice versa, so that everybody is aware as soon as those terms of acquisition are agreed. As we've already mentioned, if they're not agreed within the 6 months, a tribunal application needs to have been made to the first tier tribunal. So just bear that date in mind and really, make sure that you don't want a deemed withdrawal. Once the terms of acquisition are agreed, we then start a new clock, which is then 4 months in order to complete. So again, make sure as soon as the terms of acquisition are agreed, your premium and your lease terms have been agreed, you insert that new key date of 4 months' time into every diary, every case management system, whatever it is. If you haven't completed within that 4 months, you need to have made a county court application to protect the claim. Again, if that hasn't been made and completion hasn't taken place and that 4 month date passes, then you have a deemed withdrawal. So again, the tenant can't apply for a lease extension for 12 months. It's very important to make sure that you are aware of those key dates.
Okay, so once we have agreed valuation and terms and agreed the form of the new lease, we can start working towards completion. 99% of the time, you can agree a completion date by agreement with the freeholder solicitor. However, there are a few exceptions. It might be that you can't get a hold of them. It might be that they're non-responsive. So do bear in mind that there is a mechanism under the Act to serve a notice to complete. This can be served by either party once the terms of acquisition have all been agreed. And what that will do, what that will mean is you complete the first working day 21 days after service of the notice. If you do not complete within that 21-day period, you can refer that to the county court to enforce completion. But just be aware of those key dates that Dani mentioned. Don't serve a notice to complete if the 21 days is going to take you over your 4 month deadline. That wouldn't be productive. You're better to just make an application to the county court, which we'll go on to talk about in a minute. However, whichever method you use to complete, before you complete, obviously check that the solvency of the landlord. You need to make sure that they are still an active company and they still exist to enforce the lease extension. What you don't want to be happening is you send money to an insolvent company and then the registration gets messed up because of that, and you're left paying for a lease extension that wasn't valid in the first place. Some solicitors still use requisition forms. You'll be aware of this if you've ever worked in conveyancing. Make sure that's completed fully, should they be sent. An OS2, you can get priority period over the property. If you've submitted a UN1, however, this should give you priority. You will be notified should any changes have been made to that freehold title. So it's not always necessary to get an OS2. As well, if you've got multiple owners, make sure you establish how they wish to own it, joint tenants, tenants in common, whether there's a trust deed in place. This will need to be recited within the body of the lease extension and obviously registered at the Land Registry. So we need to make sure that we know that. One of the main ones is check for restrictions on the freehold title. Freehold titles, they can have mortgages on them, meaning that there will be restrictions and you might need consent from the freeholder's lender. What you don't want to be happening is that you complete and you haven't got that consent, which means you'll get a requisition from the Land Registry asking for that consent, and that could delay the registration and also cause complications if the freeholder solicitor isn't very communicative. On completion, the tenant will pay the premium that's been agreed. Any arrears of ground rent or service charge due under the previous lease will also have to be paid. So should you be aware that your client has a lot of arrears, make sure that they are aware that this is likely to be paid on completion. The last thing you want is a bit of a shock for your client on completion. So I tend to give them the heads up of this before we even start. The reasonable Section 60 costs payable to the landlord. So your client will be responsible not only for their own valuation and legal costs, but their freeholders' valuation and legal costs. This has to be reasonable. And as I've just mentioned, their own legal and valuation costs relating to the claim. And each party, which we'll go on to mention in a minute, will bear their costs if there's any first-tier tribunal applications or county court applications.
So once we've completed, we then move on to registration. So registering the lease extension at the Land Registry. This is done by an AP1 form. Just bear in mind there was a fee increase on the 31st of January. So the lower end was increased from £40 to £45. So I think that's premiums that are up to, I think it might be 80,000. Don't quote me on that though. But just make sure you've checked what the fee is before you look at registering it. Hopefully you did do your UN1 when you served your Section 42 notice. If you did, you then also need to apply for a UN2 with your AP1. What that will do is then remove that notice from the landlord's title, but only once the lease extension is registered. So the notice will stay on there until our lease has been registered. There is no need to get any deeds of substituted security or any lender consents from the tenant's lender because it's a statutory lease extension, so it overreaches, and therefore the Land Registry won't need to see that those lenders have consented or anything like that. Point to note at the moment, though, there is a severe backlog with the Land Registry. I think in some cases we're up to 2 years for some lease extensions. I think most of them are at about the year mark as well to be registered. So it is a long process. It's usually worth giving the tenants a heads up again at the beginning or just as you're about to register, so that if they have any plans to be selling, if that's why they've done their lease extension, then obviously they've got a bit of a wait. We can make requests to expedite applications, but the Land Registry needs to see evidence of usually potential financial implications that not expediting would have. So just make sure that the tenants do know that that isn't a quick process, just so that they are fully aware. So that's a step-by-step guide to a lease extension going quite swimmingly well. But obviously in the real world, some things don't always pan out as simple as you'd like them to. We've mentioned the first-tier tribunal and having to make an application if terms of acquisition haven't been agreed within that 6-month period. This doesn't happen all the time. It isn't, I would say I probably have to make an application maybe 10% of the time when I act for tenants, perhaps even less than that at the moment. So it's not a common thing, but it is worth the tenants bearing it in mind at the outset that this could happen. If it is necessary, so if the 6-month date is approaching and we haven't agreed terms of acquisition, we need to be preparing a tribunal application. What you need to do is physically make an application. So there is an application form, and you need to file that with the right or the relevant tribunal. They will accept it by email at the moment, and they now accept payments of their application fees, which are currently £100, buybacks. So you email the application, say that you want to pay the fee buybacks, they will then send you their bank details and the reference to put on for that. You will, in your application, you will need to state whether you are having a paper determination or a hearing. So it might be in your client's best interest to go for a paper determination. Perhaps if the terms of the lease have been agreed and you're only asking for a determination on the premium, and perhaps your premium isn't sufficiently high or the parties aren't that far apart, that might be worth having a paper determination. Obviously, if you have a hearing, then the costs are likely to be more. So it's something worth discussing with your client at that point where you're making the application as to whether or not it's better to go for a paper determination or a full-on hearing with everybody in attendance. The application will need to go to the relevant tribunal. So it will depend where the property is as to which tribunal that application needs to be sent to. The best thing to do is to simply look on the application form itself. One of the last pages on the form lists all of the tribunals, and it lists the counties that they deal with. So if you are stuck and you don't know which tribunal would hear any of your applications, then obviously have a look at the application form, and then that will tell you. If you are acting for a number of tenants and the landlord isn't agreeing terms of acquisition on more than one of them, you will need to make an application for each property. But then once the applications have been made, you can ask the tribunal to consolidate them. So that can be a good way of saving costs for the tenants, rather than having to make witness statements for every single one, or perhaps doing expert evidence for each one. You can hopefully consolidate them all together and deal with it as one. You can apply for either the premium to be determined, or the terms of the lease to be determined, or both to be determined. So if you haven't agreed one thing or both of them, it doesn't matter. You can ask the tribunal to determine whichever of those haven't been agreed. When you correspond with the tribunal, you need to always copy in the other parties that are involved. So if you are emailing, as most people are doing now, you're emailing the tribunal, whatever that may be, with the application, or later on down the line when you're complying with directions, always copy in all of the other parties so that they can see what is going on. It's something that the tribunal will require. So once you've made your application, you've paid your application fee, the tribunal will then issue directions. Those directions will probably include when witness evidence needs to be filed and served by, when any expert evidence needs to be filed and served by. If you've asked for a determination about the premium, it will probably ask the valuers to exchange their valuations, to negotiate, and by a certain date to confirm the issues that remain in dispute between them. And if you've asked for a hearing, it will obviously also include a hearing date or a hearing window. And as Verity touched on as well, the costs in any tribunal proceedings can't be recovered from the other party, so each party will bear their own costs. The landlord although they can recover their reasonable legal and valuation costs for a statutory lease extension, that doesn't include anything in the tribunal. So if a tenant makes an application to the tribunal, the landlord will pay their own costs for doing that.
Okay, so the other method should all your terms of acquisition be agreed, we have no dispute over those, and we need to complete within the 4 months. If it is that for whatever reason we can't get completion over the line in that 4-month period, you have to make a protective application to the county court, and that's under section 48(3) for a vesting order. Should you not make that application if you're acting for a leaseholder, your claim will be deemed withdrawn, which has dire consequences on the leaseholder. It means that they can't extend their lease for a further 12 months. It means they are liable for your freeholder's costs. And obviously, should you have served that notice at a sensitive period, i.e. just before it drops below 80 years, marriage value may come into place because they've got to wait a further 12 years. So all sorts of complications should that date be missed. So make sure once your terms of acquisition are agreed, you have that deadline to apply to the county court in your diaries. A court fee will be payable via BACS, and like the first tier tribunal application, you need to make sure it's served on all parties. Unlike a first tier tribunal application, costs can be recoverable, but it is dependent on circumstances. So for instance, if you've had terms of acquisition agreed and you have been chasing your freeholder's solicitor for 4 months to complete, and they have just been non-responsive, I would be making an application for costs with my county court application due to you not completing because of their unresponsiveness. It can work vice versa. So if it is that the freeholder has to defend their claim, you will probably be expected to see a costs order as well, an application for costs. So just bear that in mind if it is that your client as the leaseholder is dragging their feet. If it is that you make the application, sometimes that can make things move speedier. So an application is submitted, the freeholder will be like, oh dear, I've got to pay for my own costs for this, and normally then we can proceed to completion. If it is that doesn't happen, a hearing may be required. And if you get all the way to the vesting order, what will happen is the court will grant the order ordering the freehold to complete the lease, or in the absence of the freeholder doing that, they will sign the lease, the court will sign the lease instead. What will happen after that is that you'll be given a sealed court order, and that will need to be submitted with your AP1 that Dani mentioned previously.
So just touching briefly on assignments of claim. I mentioned earlier, if you have a tenant who's looking at selling, then they might want to start the process. They might have a buyer that wants the lease to be extended before or shortly after they purchase the property. That's fine. As we know, a buyer wouldn't be able to start the process themselves because they wouldn't have owned the property for 2 years. So what they usually do is ask the seller to start the process for them and then assign the benefit of that claim to them. That can be done at any point from the notice being served. So the notice needs to be served first, the section 42 notice, and then from any point. So as we know, sometimes sales take a bit longer than expected. So it might not be that the assignment or the sale itself takes place straight after the section 42 notice has been served. It might be during negotiations after a counter notice has been served as well. So just bear that in mind. If you do come across this situation, the lease needs to be assigned with the benefit of that notice. So this is done usually by way of a deed of assignment. That deed of assignment needs to be completed simultaneously with the transfer. So it's very important that the solicitor dealing with the lease extension is in communication with and kept up to date by the conveyancer dealing with the sale or the purchase, because they must happen on the same day. There was case law, Alderman Co Limited and Deverell, that was in the county court, and that said that the only a legal assignment of both the lease and the benefit of the notice suffices, and the assignments must be completed simultaneously. It doesn't matter that the property isn't yet registered at the Land Registry when the buyer has purchased and the buyer then carries on with the lease extension claim. There is another bit of case law in the High Court type team in Acton, which said as long as the transfer and the deed of assignment are dated the same date, then assignment has taken place, regardless of whether the transfer has been registered at the Land Registry yet. So just bear that in mind if you do have any assignments, or if your tenant is saying that they're looking at selling, or a buyer comes to you saying, oh, I'm looking at buying and then I'd like to extend my lease, just obviously warn them and make sure they're aware that this needs to be done at the same time as the transfer.
Okay, so we've spoken obviously in depth of the step-by-steps to a statutory lease extension. However, there is another way to extend your lease, and that's what we call a voluntary lease extension. And that's where we approach the landlord directly, or the leaseholder does, before they instruct to negotiate terms. Now, tread carefully with this route. Obviously, there are no rules should a leaseholder proceed down this route, meaning the landlord can offer whatever terms they want and it's not governed by any authoritative act. Also consider the bad press and the fleecehold scandal. There are obviously key things that you want to be avoiding for your clients, such as onerous ground rents, terms in the lease that are unfavourable for your client, bits and bobs like that. However, due to the fleecehold scandal, I'm finding, and I think a lot of other solicitors are finding, that landlords are being more receptive to more reasonable deals because they do not want to be seen by the press to be offering out very onerous lease extensions. Now, this will be the only option if the tenant doesn't qualify to exercise their statutory rights. So if they haven't owned the property for 2 years, this would be the tenant's only option. The landlord can simply refuse this request altogether, meaning that your client will have to wait for the 2 years until they qualify. And we always recommend advice on the premium payable. Obviously, you want to be instructing a specialist solicitor should an offer be put on the table to assess that offer and to ensure that it's reasonable. It's not our job as solicitors to be doing that. Obviously, look at the ground rent, ensure that it doesn't exceed the 251k mark. As we all know, that can cause issues with saleability and mortgage, and it could over time end up a lot more expensive than if they were to proceed down a statutory lease extension and get their ground rent reduced to a peppercorn. Also consider if they're introducing an RPI ground rent. Now, these are accepted by a lot of lenders. However, obviously, as inflation at the moment is going up, this could actually be quite detrimental for the leaseholder. So I'm finding a lot of valuers are also saying, be careful when we go down the RPI route. And lastly, there's no statutory time frame for a voluntary lease extension. There are no deadlines. You cannot enforce the freeholder to do anything, meaning that they could just rescind an offer and make you pay more later down the line. So it's a lot safer should your client qualify to go down that other statutory lease extension.
We've got a slide on reforms there. Obviously, at the Leasehold London on Wednesday, there were separate sessions for that, and I think there's been separate webinars for it as well. So we won't be going into any depth on that, other than to say, obviously, keep up to date. The new ground rent act that's coming in, we'll see the voluntary lease extensions changing slightly over time. As of at the moment, though, just make sure that you are aware and keep yourselves up to date on that. Again, our contact details in case you do want to get in touch with us if you've got any specific questions. I think we're pretty much bang on time otherwise, but feel free to get in touch with us. and sign up to our knowledge hub if you wish. We do quite a lot of webinars, white papers, and feel free to give us ideas for future webinar topics that you might want to see as well. And I think then that just leaves us to say thank you very much.
Thank you, ladies. That was great. Really, really informative. I can't see that we've got any questions coming at the moment, so I think you've probably pretty much covered everything if there's no questions. I just wanted to say one last time a thank you to all of our sponsors for the Leasehold Conference and the Leasehold Knowledge Week. So that was our headline sponsor, FR Consultants, Foresight Consulting, BBIS Heating, Beehive Block Management, Fixflow, Future Group, JM2 Group, MRI Software, PropRec, Present It, Realty Law, Tetra Consulting, and TNA Building Services. Was a bit of a mouthful.
Well done.
We have some more webinars coming up next week and some more over the next sort of 4 weeks going into April. So if anyone would like to join us for them, then please do sign up via the News on the Block website. Otherwise, thank you ladies both for your time on Wednesday and again today, and hopefully I will see you both soon.
Thanks, Vicky.
Okay, thank you everyone. Bye.